Hello, my name is Christian Gomez, the Research Project Manager for the John Birch Society. I'm also a contributor for the New American Magazine. Today's topic is Article 5 Revisited. So what is Article 5? You may have heard this term used around, but not quite familiar with what Article 5 is. Maybe you do know what it is, but we'll review it anyway. So Article 5 is the section of the U.S. Constitution that states how the Constitution would be amended. Article 5 states, the Congress, whenever two-thirds of both houses shall deem it necessary, shall propose amendments to this Constitution or on the application of the legislatures of two-thirds of the several states, shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes as part of this Constitution when ratified by the legislatures of three-fourths of the several states or by conventions in three-fourths thereof, as the one or the other mode of ratification may be proposed by the Congress. So essentially, when it comes to proposing amendments to the Constitution, you can either have two-thirds of both legislative chambers of Congress, which would be the House of Representatives and the U.S. Senate, to pass and propose the amendment to the Constitution, or the alternative method in Article 5 is Congress calls the convention for proposing amendments on the application of the legislatures of two-thirds of the several states. So in either case, which in either case shall be valid to all intents and purposes as part of this Constitution when ratified by the legislatures of three-fourths of the several states or by conventions in three-fourths thereof, as the one or the other mode of ratification may be proposed by the Congress. And that's very key to remember here. There's no guarantee that the state legislatures would even be ratifying whatever might come out of a Article 5 convention if one is ever held, or even if Congress proposes an amendment, Congress can decide to have special state ratifying conventions to ratify that amendment if Congress believes that the amendment is not one that your state legislature might approve of. An example of this would be the 21st Amendment to the Constitution, which was the amendment that repealed prohibition. Various state legislatures were adamant on keeping prohibition at the time, and Congress wanted it to be repealed. So they selected the mode of ratification of special conventions of the states to ratify it, circumventing the will of the people through their state legislatures to get the 21st Amendment added to the Constitution. So, Article 5, towards the end of it, says, provided that no amendment which may be made prior to the year 1808 or 1808 shall in any manner affect the first and fourth clauses in the 9th section of the first article, and that no state without its consent shall be deprived of its equal suffrage in the Senate. Now we're just going to focus on the first part of Article 5, not the parts I just read there, but I wanted to mention them so nobody says you didn't mention all of Article 5. But focusing on what matters, essentially, there are two ways to amend the Constitution according to Article 5, and two ways to ratify it, which Congress is totally in charge of the two ways to ratify it. So all 27 amendments to the U.S. Constitution, it should be noted, including the first 10 amendments, what we refer to as the Bill of Rights, all originated out of Congress and then were transmitted to the states, three-fourths of them, for ratification. We've never had a so-called Convention of States or Article 5 convention since the adoption of the U.S. Constitution. So right here on the screen you see a man named Mr. Mark Meckler. Mr. Mark Meckler is the president and founder of Convention of States, an organization that since about 2014 has been advocating for an Article 5 convention, which they refer to as a Convention of States. Now, Mr. Meckler will go around the country telling various legislators and even constituents in various districts that what he wants is a convention of states and not a constitutional convention, as if to say that these two are separate. What Mr. Meckler is trying to explain, according to his interpretation, is that a constitutional convention is only meant to rewrite a constitution or draft an entirely new constitution, whereas a convention of states is simply limited to just amendments. So this is safe, and that isn't. And he even claims he would oppose a total rewrite of the Constitution. That's what Mr. Meckler says. But is he right? When he says convention of states, is that different than a constitutional convention? Sorry, folks, to inform you, but Mr. Meckler has not been honest with you. A constitutional convention is the same thing as a convention of states. What Mr. Meckler refers to as a convention of states is in fact also a constitutional convention. The two terms are interchangeable as far as the Article 5 convention process is concerned. So when we look at Black's Law Dictionary, which has been the premier legal dictionary used by judges and students of law and lawyers for over a century, the second edition of this dictionary, published way back in 1910, through the most recent editions still in print today, consecutively have defined the term constitutional convention as a duly constituted assembly of delegates or representatives of the people of a state or nation for the purpose of framing, revising, or amending its constitution. So the definition, the legal definition of constitutional convention is any convention that can not only rewrite the Constitution, yes, but also even amend it. So when Meckler says that an Article 5 convention of states is only for amendments and a constitutional convention isn't, or when Michael Farris, one of the other former leaders of convention of states who still advocates for it, says that a constitutional convention is only for rewriting it, what's their source? Look at the legal dictionary, Black's Law Dictionary. It says otherwise. It says that constitutional convention can also refer to amending the Constitution. In fact, when you look at the literature prior to 2014, everyone who was talking about an Article 5 convention, whether they were staunchly for it or staunchly even against it, always referred to it as a constitutional convention. It was only in 2014, around that time period, when Mr. Meckler founded Convention of States, that he started calling it a convention of states, because most legislators and people were well aware that a constitutional convention could also rewrite the Constitution. And since many people oppose the fear of a runaway convention, he renamed it into something else so as to deceive you and your legislators to go along with this process, which is still the same risky and dangerous process if it were to be done in this day and age. So let's go further on. How does the convention method even work? Well, the way it would work is that the only thing that is for sure guaranteed to the state legislatures is just the ability to make application to Congress. Mr. Meckler says often that the convention process under Article 5 is one in which the state legislatures control it from the beginning to the end. But we just read Article 5, and I even broke it down a second time right after, and nowhere in there does it state that the states control the process. The only thing that was stated in there was that they make application. That's it. They just apply for the process. The rest is up to Congress until the convention is called. And the states are not in charge of an Article 5 convention. So once 2/3 of the states apply for a convention, which would be about 34 out of 50, then Congress is supposed to call a convention. So once a convention is called, the responsibility for writing the rules of that convention, electing the president of the convention, who will act as the presiding officer of the convention, and for even proposing the amendments themselves, that rests entirely on the delegates. The state legislatures have no say on the matter. So when you see these bills and other resolutions proposed to impose limitations or to create rules to govern a future Article 5 convention, there even have been organizations which have tried to have a rules-making convention for a future Article 5 convention. None of that has any bearing. They can do that stuff. They can do it in the sense that they can go ahead and draft it. That's real cute. But legally, it has no legal authority. The delegates themselves, whoever they are, and we'll get into that in a moment, they'll decide the actual rules that govern the convention. It will not be determined by the state legislatures or even by Congress. The delegates get to pick their rules once the convention convenes. So who would the delegates be? That's a very important question. Now, Mr. Mark Meckler says that it's going to be the state legislators. Of course, when we just read Article 5, what part of Article 5 says that the legislators will be the delegates to the convention? Is it possible that these folks on the screen here could be delegates to an Article 5 convention if one were to be called? AOC, Nancy Pelosi, and other Democratic legislators in Congress? Could they be delegates at a future Article 5 convention? Well, some say that they would not be eligible, and I'll explain why they say that, and also why they're probably wrong. Article 1, Section 6 of the Constitution says, "No senator or representative shall, during the time for which he was elected, be appointed to any civil office under the authority of the United States, which shall have been created on the emulance whereof shall have been increased during such time, and no person holding any office under the United States shall be a member of either house during his continuance in office." Essentially, what this is explaining here in Article 1, Section 6 is if someone is elected to the House of Representatives, and let's say they were also running for the U.S. Senate simultaneously, they couldn't hold both seats. They'd have to choose, do I want to be in the House or the Senate? But they can't simultaneously serve as a House member or a Senate member. Or let's say the president, whoever he or she may be in the future, decides, oh, I'd like to have your senator be my Secretary of State. Well, that person couldn't also be a sitting U.S. senator and the Secretary of State, or serving on the Supreme Court of the United States, for example, or a federal court, while still serving in the capacity of Congress. So would this apply to an Article 5 convention? Would members of Congress or federal judges be barred from serving in an Article 5 convention? Well, according to the American Bar Association, they produced a study in 1974 trying to answer the questions of an Article 5 convention and how that would function. And according to the study, which was entitled Amendment of the Constitution by the Convention Method under Article 5, this is what the American Bar Association said. A state-elected delegate to a national constitutional convention does not meet the standard. In other words, Article 1, Section 6, the prohibition that they can't serve in other parts of other branches of the government for the sake of checks and balances, that doesn't apply because a constitutional convention is not one of the branches of government. In fact, if a constitutional convention is ever convened, it is actually a supranational legislative body outside of the limitations of the Constitution, because it has this inherent power to either create a new Constitution or amend it, and that goes beyond any kind of constitutional limitations. So that's what the American Bar Association said at the time. They also said at the time, the office of the United States must be an appointment office created under Article 1 or involve duties which would encroach on the principles of separation of powers. Like I explained earlier, Article 1, Section 6 only applies to serving within one of the different branches of the federal government as defined in Article 1 of the U.S. Constitution. So with this conventional wisdom, you can bet that your member of Congress, well, maybe not your member of Congress specifically, but that members of Congress would indeed try to be delegates to a convention. In fact, if we look at historical precedent, back at the original Constitutional Convention, the Philadelphia Convention of 1787, 41 of the 55 delegates convened there had previously served in the Continental Congress, or the Congress under the Articles of Confederation at the time. And in fact, 10 of the delegates present at the convention were simultaneously serving as members of the Confederation Congress, despite a similar prohibition on the Articles of Confederation. Even with their own limitation on the Articles of Confederation to protect separation of powers there, they knew that wouldn't apply to a constitutional convention. So based on this historical precedent, could these individuals be delegates to a constitutional convention while still serving in the House of Representatives or whatever branch of the federal government they may be at the time in the future? Absolutely. Speaker Pelosi could in fact be a delegate to the convention, and so could AOC. In fact, there's even a good possibility that that Nancy Pelosi may also be the president at a future potential Article 5 Constitutional Convention. And I'll explain how that could happen. So that leads us to this question: how many delegates would be sent to a Constitutional Convention? Well, back in 1973, there was this bill that passed the U.S. Senate. It didn't pass the House, but it passed the Senate. And this gives you a gauge of how Congress believes an Article 5 convention or Constitutional Convention would occur. In fact, this bill was entitled the Federal Constitutional Convention Procedures Act. And according to the Federal Constitutional Convention Procedures Act, it says in Section 7A of that bill that passed the Senate in the 70s, a convention called under this act shall be composed of as many delegates from each state as it is entitled to senators and representatives in Congress. In each state, 2 delegates shall be elected at large, and 1 delegate shall be elected from each congressional district in the manner provided by state law. In other words, the exact number of members that are in the House of Representatives and U.S. Senate, that would be reflected at an Article 5 convention. And considering the fact that Nancy Pelosi is the elected Speaker of the House of Representatives at the time of this recording, and has been for quite some time, and even in the past when George W. Bush was president, it's very well possible that we have a similar composition of delegates based off of congressional districts, that she could be elected the president of a Constitutional Convention based on the math involved in that case. So would it actually be 1 state, 1 vote? Because Mr. Meckler says that we have no reason to fear the possibility of the big progressive states like New York and California dominating, because it'll be 1 state, 1 vote. Wyoming will have equal say and vote as New York, according to Meckler. But is that even true? Would it even be 1 state, 1 vote? Well, let's look further. This is taken directly from the Convention of States website. They state here, voting at an Article 5 convention will be 1 state, 1 vote basis. And this is their explanation for why they believe that. This is a matter of precedent, they say. I'm glad they're talking about precedent, because we're going to talk a lot about precedent. So I'm glad to see the Convention of States believes in the matter of precedent. That is actually good, and we'll get into that later on. But for now, let's just focus on this question. The universal precedent for voting at an interstate convention is on a 1 state, 1 vote basis. It is not a convention of delegates, but a convention of states. So when they say convention of states, they're actually trying to secretly imply that it's a 1 state, 1 vote, which there's no guarantee of that. But let's keep reading. Let's read what they have to say. This is the reason Article 5 did not need to specify the number of delegates to be sent by each state. That's pure speculation. Where did they get that from? But let's just keep reading what they state. The states can send in as many delegates as they like, but each state only gets 1 vote. Okay, based on what exact fact? This is also a matter of history, they say. In 1788, the Virginia legislature correctly called this process a convention of states. Actually, if you go back to it, it says convention of the states, but that's just splitting hairs. But nevertheless, in the first application ever passed under Article 5. So right after the Constitution was, actually right before it was ratified, the Virginia legislature was the first state ever to apply for a new constitutional convention under Article 5, and in their application, they called it a convention of states. And also there's a Supreme Court case in 1831 known as Smith v. Union Bank of Georgetown that uses the phrase convention of states. Now I would invite all of you to look up that Supreme Court case, Smith v. Union Bank of Georgetown. You can find it on the Library of Congress website. That Supreme Court case has nothing to do with Article 5, nothing to do with amending the Constitution. It has to do with tariffs and trade. So why they would mention that is kind of odd, but they probably assume you won't look into that. So that's why they use it as justification. But let's focus on what was said earlier here. The Virginia legislature passed an application for an Article 5 convention. They called it Convention of States. Well, New York State